My name is Virginia Nelder. I'm a senior legal researcher at Kenya Law Reform Commission. The KLRC is expected to undertake regulatory impact assessment of proposals and existing legislation and administrative processes and report on the outcome for the purpose of policy development and review. And so the project that I'm talking about today will provide the research necessary to make evidence-based policy and legislative proposals relating to access to justice in Kenya. Now, Dr. Jonathan Andrew Harris is an assistant professor of political science at the New York University in Abu Dhabi. He studies institutions and political behavior in Africa with a focus on Kenya. So Dr. Harris has partnered with the KLRC to undertake this study on the effects of observation and research assistance on legal outcomes in Kenya. So while Dr. Harris is the project director, KLRC is the implementing organization, and I'm the project coordinator. So before I continue with the nitty-gritty stuff, let me just emphasize the fact that Dr. Harris is the social scientist in this relationship, and I just happen to know a little bit about the legal system in Kenya. So unfortunately, he was not able to be here with us today, so I ask you to be a little bit gentle with me. So, background. After promulgation of the 2010 Constitution in Kenya, the judiciary undertook a transformation agenda, which Bilal has already referred to. The current phase of transformation being undertaken from a bottoms-up perspective between 2017 and 2021 is predicated on the theme Sustaining Judiciary Transformation for Service Delivery. It builds upon a previous agenda of institutional building and capacity development enhancement, by shifting a focus to enhancing service delivery by increasing efficiency and effectiveness at individual and system levels, as well as individual accountability for performance. So the SJT consists of 5 strategic initiatives, including enhancing access to justice and clearing case backlogs. Enhancing access to justice predicated on 4 principles: changing work methods, focusing on individual accountability and institutional responsibility, enforcing standards and policies, and a focus on pro-poor practices and policies. Now, with respect to case backlogs, at the end of December 2016, at the magistrates court level, the magistrates court had a backlog of 226,459 cases. So the initiatives to clear this backlogs includes ensuring proper documentation during trials. Now, the absence of sound legal processes and high-quality legal judgments creates an access to justice challenge by eroding the rule of law, reducing the predictability of legal decision-making, and delegitimizing the state's enforcement mechanisms. So the question is, how can the quality of legal processes and outcomes be improved in an under-resourced, overburdened context like Kenya? So the vision of the project is to address these issues through 2 interventions: courtroom monitoring and case clerks. So the time frame for the project is March 2018, so we've just started, to late 2020 with the possibility of extension, depending how it goes. So in 2018, we're focusing on developing the research design and protocol and hiring and training courtroom observers and case clerks. Over the course of 2019 and 2020, the interventions will be rolled out in approximately 6-month interventions. Sorry about that. Existing observational research suggests that investments in additional staff and training significantly improves judicial efficiency. And similarly, anecdotal evidence from the Kenya National Commission on Law Reporting suggests that the provision of administrative and research support to magistrates improves the quality of judgments. So it's expected that the allocation of case clerks to magistrates will increase the quality of written legal judgments and the speed at which they are composed and delivered, improving the ability of the judiciary to grapple with this massive case backlog and also reducing the likelihood of appeal. The second intervention involves case monitoring. So advocacy work by civil society organizations in Kenya provides evidence that simply observing a public proceeding may improve the quality of that proceeding, both in process and in outcome. the Kenyan NGO Wildlife Direct found that monitoring wildlife crime cases improved the conduct of the magistrate and the availability of court records. So our design, however, is an important departure from previous work on measuring the quality of courtroom procedures, which usually depends on looking at appeal rates. The idea that people being unhappy with a judgment will appeal it. In our project, we're actually going to be measuring the quality of the actual legal proceedings relative to the administrative guidelines setting out how a case should proceed. Okay, the first intervention, which is courtroom monitoring, will. Where's the sharing message? Nope, still there. Okay. First intervention, we'll randomly assign one courtroom observer to specific cases, following the same case throughout its life cycle. Okay, thanks. Since some types of cases, for example, sexual crimes, may proceed quite differently from other types of cases, for example, traffic offenses, the observation will be run across several types of cases, focusing on cases that occur frequently in magistrates' courts and are likely to have the most impact in terms of improved outcomes for all participants in the system. We aim to follow the largest percentage of case types as feasible given the funding and time constraints. So observers will be current undergraduate law students hired through the Law Reform Commission's partnership with Strathmore Law School. In the second intervention, clerks will be hired as interns from the class of graduating students from Kenya School of Law. There's one law school in Kenya for the entire country. It trained on judgment writing, legal research, and sentencing guidelines prior to their first assignment. They'll then be randomly assigned to magistrates for several months. So thus, at any point in time, some magistrates will work with a clerk, while others will not. And as a result, comparing outcomes of cases from magistrates with a clerk to those without a clerk will enable quantifying the effect on the quality and efficiency of the legal process and outcome. So a baseline analysis of written judgments of magistrates in the control and treatment groups before the treatment begins will allow us to measure changes in quality and timing in judgments by individual magistrates. So at this point in the project, we have determined which case types to observe. Robbery with violence, which is one of the only offenses in the Kenya Penal Code that attracts the possibility of the death penalty, but is very easy to commit in terms of the elements of the offense. And therefore, there is a very high occurrence rate across the country with significant potential negative outcomes. Running down, which is basically civil claims for damages in relation to a hit and run. Traffic offenses, which includes a very broad range from failure to wear a seatbelt, to driving without a license, to failure to have the correct permits. And then the final is sexual offenses. Here we aim to focus on defilement, which is essentially sexual assault of a minor. To measure the effect of our interventions, we will look at several indicators. The time between the final day of hearing in a proceeding and the delivery of the judgment, the number of judgments that magistrates complete in a month, the quality of the judgment text, which is measured on indicators of sound legal reasoning. So, for example, analysis of evidence, reference to the statutory framework, and congruence with legal precedent or sentencing guidelines. We'll use a human-coded content analysis, so we plan to use automated measures of writing quality and judgment quality. And finally, the case outcome, both in terms of the verdict in criminal cases and the finding of liability and the amount of damages awarded in running down cases. We have also determined how to undertake the randomization process by using a web-based randomization tool, which works by inputting the case number into an online form, which then uses a formula to randomly assign the case to either the treatment group, control group, and the third group of cases which are not included in the study. So to test this tool, we've had 2 research assistants who we're calling our guinea pigs, who we've basically just sent out into the courts to follow the research methodology and note any problems that they have so that these can be addressed and our design can be tweaked before the full implementation. So they've made contacts with officers in court registries, so they're aware of the project and will provide any assistance needed in terms of practical issues, for examining, determining the cases to follow, where to sit in courtrooms, et cetera, et cetera. The research assistants have also assisted in developing checklists of both procedural and substantive steps in the 4 case types that we're going to follow. That will form the basis of an app that will be used by the courtroom observers to follow the procedural steps in the proceedings. To validate our randomization procedure, we have been generously granted access to the judiciary's case information database called the Daily Court Returns template, which contains data from every court across the country. And if our online randomization tool works, we should have equivalent treatment and control groups in terms of the data we observe in the DCRT. We'll also use data from the DCRT to determine which courts to include in the study so that we have a sufficient number of the 4 case types to obtain a statistically significant sample. So in addition to the guinea pig phase, we also have projected the project at an annual colloquium for magistrates, which were attended by all magistrates across the country. So they've been sensitized both on the purpose of the project and the methodology. We hope this will address any potential for magistrates to be uncomfortable with having observers in their courtrooms, and any potential for magistrates to feel that they've been overlooked in terms of being assigned a case clerk. And no real significant concerns were raised that we feel can't be addressed in the methodology. There was one concern raised, but I'm going to skip it. If I have time, I can talk about it. Our next steps include hiring and training of observers and clerks. So to this end, we've partnered with Kenya's Judiciary Training Institute to develop training materials and curriculum based on the same materials and curriculum used to train magistrates in respect of the 4 case types that we'll be following. It also includes training on research and judgment writing for clerks based on, again, similar training provided to magistrates by JTI. So finally, while we're very happy with our progress to date in terms of research design and development of tools, the challenge we've encountered is simply administrative in nature in terms of getting all of the contracts finalized with Treasury Department in Kenya and et cetera, but hopefully that will all be sorted out shortly. Thank you very much. I can answer any questions. Kind of answer questions. Yep.
So just 2 quick questions. One, are you worried about spillovers both at the case level? Are observers going to just pop in and out of the courtroom every time a case is heard and then leave as soon as it's over? And do you worry about how their presence may actually generally affect all the cases that come that way? And similarly, spillovers between magistrates, where you give one magistrate a resource, the magistrate next to him or her gets either benefits from that resource by getting or getting a lower caseload overall, etc. So how would you think about those? The second is that I wasn't really clear about how the data is going to be collected. Because the data quality in principle would be totally endogenous to whether or not you have somebody in court observing you, then the magistrate is like, oh, this case I'd better write up better. But that may have nothing to do with the actual quality of the decision. And similarly, there may be better recording of administrative data for cases which are observed, and particularly for cases for magistrates which have case clerks. They're just going to record data better in the DCRT, and that might just be a pure Hawthorne effect without actually changing the actual outcome. So.
Okay, I think I can answer those questions. The first one, in terms of the spillover, the observers will just be in the courtroom for the cases that we have assigned them to observe. So yes, they will pop in and out, but they'll be going to different courts around the country, following just the cases that end up in the treatment group. In terms of spillover of the magistrates and the judgment writing, I'm not sure how to answer that question.
One thing we want to ask, Andy asked us actually on his behalf, if people don't mind, if you have a question, just writing it down, and you can either email it to me or email it to him directly, but he really is bummed he can't be here and wants to still receive all the detailed feedback. So it's probably easier if you're the one posing the question, if you could just send it to us later.
And I want to know the question. I understand the question. It's just I'm not sure how to answer it. And then the second question, which was just... right. So the way that the observers, yeah, I think I understand it, maybe, will be actually like app-based, right? So in the courtroom, the observers, and it's just a checklist. Basically, they'll be following the steps in the proceeding, yeah. So, and then in terms of the judgments, it will just be the judgments that come out of the cases that we decide to follow. Does that answer the question? I'm not sure that it does, but.
More or less, we can
go. Okay. Any other questions? I will do my very best. Okay, thank you very much for your time.